Morning, breaking news, breaking news, breaking news, breaking news. I don't know if you can read it or not right there, ladies and gentlemen. That's right, Bowerman versus Field Asset Services. Hey, I don't want to say I'm vindicated. I don't want to say that I told you so, neener. I don't want to say any of that, even though it would feel so good to get it out and say it. I'm not going to do it. But what we are going to do, ladies and gentlemen, I'm going to take a pause for the cause here. This morning's portion of property preservation news you can use, brought to you by Broken Arrow Auto Repair at 3010 Highway 95A, Silver Springs, Nevada, 775-577-2408. Give Doug a call. He will get you squared away. All your auto repair and needs under one roof right out there, Silver Springs, Nevada. The guy is off the hook. He can really get you squared away. Ladies and gentlemen, I'm going to get myself settled in here a little bit. I got to get some coffee, of course. We got it percolating in the back. I don't know if you can hear it or not. But we are going to talk about the case. I want everybody to see something here. Right there at the top. Look at that date. Ah, yes, it was an Irish thing, I guess. St. Paddy's Day. This was filed with the clerks of the court yesterday, March 17th, 2017. What it is, ladies and gentlemen, United States District Court, Northern District of California, FAS decided to fight the employee independent contractor issue. I'm going to go through each step. This is a 50-page brief. I might take a couple breaks in between and push it out in 2 different videos, 3 different videos this morning. I don't know. But we're going to go over this step by step, as I've done with many contracts for the property preservation industry. I'm going to also see if we can't tie in to a couple of the Facebook groups out there and see if we can't get them pushed into the Facebook groups so you guys understand what's going on. Needless to say, this is industry changing. This is a game changer for all the rules and all the regulations in the industry, ladies and gentlemen. Get your coffee. Sit on down, because this is going to blow your hair back this morning. You are not an employee. I mean, an independent contractor. I have been saying since 2010, the industry is full of implactors. That's right, implactors. An incorrectly identified employee as an independent contractor with specificity to the property preservation industry. I got Oxford going to make that a word and get an entry in the dictionary just because it is so prevalent. That's right. The day of the implactor is over in the property preservation industry, ladies and gentlemen. 2 issues. First and foremost, before I get started, let me pause and come back. I got to have coffee, folks. I got to have coffee. Hang on 1 minute. All right, ladies and gentlemen, I am back. What I think I'm going to do, I'm going to set this up. We'll go over the gist of this, and then I'll get into the meat of it. Let me see here. Scooby-Dooby-Doo. Ba-dooby-dooby. First off, FAS wanted to separate the lawsuit. They wanted to have each individual member of the class. For those of you who don't understand what class is, if 5 of us, it takes 3 people to create a class in what they call a class action lawsuit, or the class, which is, or in this particular case, the class would be the plaintiff in the legal case. That would be the adjective that is given to me and everybody else that's involved in the lawsuit. If we're all involved in the same lawsuit, we're called the plaintiff if we're bringing action and we're bringing action against somebody who has to defend our accusation, or the defendant. In this case, the defendant is Field Asset Services. And this is huge. This is huge for a couple reasons. First and foremost, the Hearst v. Buckzek case is used against FAS in this. And before we get into this, I want to talk just a little bit, and I'm going to address this. This is directly at you, Eric Miller, and the board of directors of NAMFS. You have allowed that institution, you have allowed that organization to become garbage. You have allowed the deterioration of an industry, all for pecuniary greed. And I am sorry, Mr. Miller, you no longer deserve respect from anybody in this industry. The Hearst v. Buszek case was decided back in 2010. And you should have straightened things out right then and there. You should have said, hey, whoa, we have to stop this. We cannot let this go on anymore. And instead, you allowed the industry to parlay itself and pyramid itself. And now it is rapidly falling in on itself. You have a Ponzi scheme going. And as more and more attorney generals and attorneys call me for advice on the industry, on procedures and whatnot, I just turn over these emails. I turn over the articles, and I believe you know that there is a whole dossier on NAMFS. And as Anthony Weiner has done, Anthony Weiner is saving his ass right now, telling stories. He's ratting all the rats out. Somewhere in Washington, D.C., you can guarantee the FBI has him sequestered with his little laptop, asking him questions about everything in his little life insurance file. I'm going to bet you right now, people on the board of directors, former people like the pig, Heather Berghorst, Amanda Buckzek, that could just go out and flaunt. The Jay Cheap Suit Gazinski guy up there in Michigan. All these people who want to go out and flaunt all the money they spend while they cheat labor out of their money. That has all become evidence. Evidence. Oh, yeah, and by the way, the little asswipe that was the public information officer for the Buszek that wanted to tell me that the case against them, Hearst v. Buszek, was not precedent. Oh, you know what? Thank you very much. Because laughing right now is about the only thing that feels good. That's how bad I hurt. Thank you. Yes, it is precedent. It's mentioned right here in this lawsuit. Hey, the background on this, of course, FAS is a preservation, maintenance, and repair service company for foreclosed and real estate-owned properties, maintains a network of quote-unquote vendors to perform the work at the properties of the clients. Vendors may range in size from sole proprietors to large corporations. I want everybody to stop and think for just a minute. Mom and pop shop is your small sole proprietor. Alliday LLC with 25 employees and 5 field supervisors is a company. So, here's what FAS argues: it does not provide property preservation services, but it identifies itself as the premier property preservation, REO, maintenance, and repair service company in the United States, servicing more than $2 billion in residential assets on behalf of our clients. FAS. This is what the court said to him. I love it. The argument appears to be based on semantics. It is addressed in the discussion of secondary factors. It does not create a genuine dispute. Field Asset Services got their lunch handed to them here, folks. They got slapped like the bad stepchild in the corner, in the backyard. The dog is chasing them around and around and around and around and around, and nothing's going on. All he is just standing there in the corner looking stupid because he don't know what to do. That's what's happened in this case, ladies and gentlemen. I'm not one to gloat, but that bitter taste just kind of popped out of my mouth now. You know what I'm saying? Yeah. Here's one of FAS's arguments. While FAS insists that it does not require vendors to obtain a business license, the vendor qualification packet references the applicant's company, see vendor qualification packets, an opening letter attached to one of the 2013 vendor qualification packets. All documents and certificates of insurance must be exactly match the company or sole proprietor name listed on your W-9. I mean, it's just unbelievable. I'm looking for a specific part here where the judge actually slaps. Let me see here. That's all talking about the case. But one of the things that FAS wanted to do in this case, ladies and gentlemen, was they wanted Civil Procedure 23 creates a class, is what it does. Let's get back to that for just a minute. What they wanted to do was separate everybody out and have a separate trial for everybody, which I think personally, well, and they know by doing that, me, you, and everybody independently probably doesn't have the $5,000 or $6,000 to go into a trial to tie up, and that's why they did that. And the court shot them down. We all have the same complaint. So the court shot them down. Since we all have the same issue, we're all raising the same questions. A class is so numerous that joinder of all members is impractical. There are questions of law or fact common to the class. The claims or defense of the representative parties are typical of the claims or defenses of the class. So those are kind of things that go on. That's how the court. But the court shot that down. They did separate a couple members in here because of personal issues going on with their businesses and them as an individual working for FAS. There was kind of a double listing in the list of plaintiffs. But let's get into some of the good stuff here. Let's see here. The motion to decertify was completely shot down. That was kind of moot. Let me see here. Throughout its motion, FAS fails to carry a line of attack, though the requisite legal tests, according, it has not undermined the sufficiency of class certification. In other words, take a hike. Let me see. FAS begins its argument, finding commonality, most critical factor, the right to control. Now, I have been saying this for a long, long, long time, that there are numerous issues in property preservation that create, quote unquote, control. You're told, now I want you to stop for just a minute and think of everything. When I started in, you didn't tell me to go buy anything. I went and bought my own tools. I went and bought what tools I needed to do my work, etc., etc. We bought our supplies to do the jobs that we were doing. We negotiated our own fees. Then all of a sudden, this flat fee stuff started coming in, and when Cypress wrestled the Big 7 Fannie Mae contract from FAS back in 2000, at the beginning of 2011, that is when the industry declined overnight rapidly with the fee structure. Cypress bid the thing so low, and Cypress was already paying low. Another company that's being investigated by Department of Labor right now because they're giving stuff away, and that is so. Anyways, identified the concern that vendors' business operations were so varied that there could be no common answer regarding independent contractor status under the multi-factored independent Borello test. And the judge said, poppycock. But again, back to the control thing. One of the issues that came into play here was they told you what supplies to buy. Remember when they said you can no longer use the dollar air fresheners, 3 for $1 in the box? You had to use a specific, and I'm drawing a blank on the name, but they called a brand name out, gel air freshener. It had the top screw off. They were that big. They were like $1.20 a piece, and you had to put 3 of those in a house. And oh, by the way, we're not giving you a raise on the fee. That came into play here in the thing here. Particular factor assessing the plaintiff is employer factor. One particular relevance to FAS right to control is the agreement defining the relationship between the parties. There is no single contract at issue during the class period. I've already found that all vendors execute the same or similar independent contractor agreements. The same or similar independent contractor agreements, which there's another factor. I can see my timing on this, ladies and gentlemen. We're going to do this in a couple different segments. This is a warm-up because I'm just getting wound up here this morning. We'll do this. Here's another one. Predominance. In the certification order, I summarize the prior order's findings and found that plaintiff's new class definition successfully addresses the concerns regarding predominance set out in the prior order, certification of the order at 16. I highlighted how the new definition limited variations among class members' ability to negotiate and dependence on FAS for revenue. Now, here's one of the things. You might be doing 1 or 2 things for somebody else, but when you're doing $240,000 of work a year and $200,000 of that is from one company, they control you. Make no mistake about that, ladies and gentlemen. They do control you, and that was one of the big issues. Oh, well, they're free to work with other people, but one of the complaints is when an order mill first gets you in their crosshairs, and this is part of the MO of the game here, they bury you in work. So you can't do anything else for anybody else. You don't have time to think, hire employees, et cetera, et cetera. Go shop yourself. Go find new clients. You just don't have the time. And I remember one of the things when we were going back and forth with FAS. The guy said, "Are we the only company you're working for?" I go, "You're the only." I go, "We haven't had time to shop ourselves to other companies, if you will." And he goes, "Oh boy." And I knew right then and there, that's when I started looking into a whole bunch of stuff, ladies and gentlemen. And that was when I said, just because it's an at-will termination contract and blah, 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 all these people. Let me see here. How about superiority? FAS's argument devoted to attacking the superiority of class treatment lists a page of legal authority focused on ascertainability or administrative feasibility, superiority, and manageability requirement, but it contends the rationale is equally applicable here. The fact that FAS could not identify precedents tracking its reasons against certification is telling. In other words, this is going to get worse. That is the judge being very nice right there. This is going to get worse. Ladies and gentlemen, I don't know how many of you work for Safeguard or Cypress or PK Management or BLM, MCS, MSI. This is freaking huge. This is the end of part 1. I'll be back with part 2. And it'll take about an hour to process and push it through, ladies and gentlemen. Let's have a good time. Don't go anywhere. I will be right back.